we'll call 124054, State of Kansas versus Mark Scheetz. Overmeyer?
Thank you. May it please the court, the state appears by Stephen Overmeyer. Madam Chief Justice, may I please reserve 3 minutes for rebuttal?
3 minutes is granted.
Thank you. Just to give the court an idea of what my initially intended batting lineup is, I was going to start briefly with the 5th issue in the petition for review and proceed then to the 2nd issue on preservation and issues 1, 3, and 4. With regard to issue 5 concerning the cumulative error rule, I filed a 609 letter concerning State versus Couch, which is a case this court recently had considering the cumulative error rule. And the court basically said that you look at whether the cumulative errors impacted each count in the case. And in that case, it did not. I had cited in the state's brief a State versus Carr, which was another case where the court looked at each count individually. And I cite these cases because the Court of Appeals just had a wholesale reversal of all 6 counts, including a count involving witness intimidation, where the defendant sent a letter or tried to send a letter to the victim, claiming to be from a concerned citizen, indicating you should not it'd be in your best interest, or you should not testify. I think embarrassing things will come out. Issue 5.
How do we determine which errors bleed into everything? I mean, isn't that kind of the point of cumulative error in some respects, is that we look at it and it impacts not just the issue in question and the charge specific to that error, but how does it, what's your suggestion about that? I understand what you're saying is that it had nothing to do with witness intimidation, that some of these errors had nothing to do with that, but
Right.
How does it not? How do you address that concern?
This court in Carr addressed it that way, and looking at what the errors were and what counts it addressed, instead of just reversing for everything. And here there wasn't, none of the complaint of evidence on the 6455 or the closing arguments dealt with the witness intimidation or the sexual exploitation of a child count, where you have on the defendant's iPhone, the Court of Appeals said pictures of unclothed females. I think they're really underselling the facts in that case. It was more than unclothed females. And if you look at the state's brief of appellee at page 9, it sets out just the lurid nature of these pictures of the victim that were on the defendant's phone. It was more than unclothed females. There was no testimony by the defendant concerning this or the witness intimidation. In fact, the state was enjoined from cross-examining the defendant on these issues because defense counsel did not go into that on direct, which I think is an interesting issue in itself, but we didn't cross-appeal whether or not you waive your right on everything when you testify. But anyway, the unclothed females was undersold. In addition, the evidence concerning whether the penis was erect in the Snapchat that was sent, and that's been clarified. We know that it was. It's more than just a reasonable inference that could be argued. It was in the defendant's own statement to the KBI that it was. So that also colors the cumulative error, not only as to counts 5 and 6, but as to the first 4 counts. Issue 2. It concerns preservation, and the state contends that the Court of Appeals just had a wholesale disregardance of State versus King and State versus Bliss and KSA 60404 in addressing what it thought. I'm sure it thought was an interesting issue because it spent 15 pages in the published opinion addressing the 6455 issue once we, get past what the nature of the objection was.
I stop you. I mean, I know you want to go through stop you there because I've tried to track. After I got through the entire case, I decided I was trying to track preservation issues. So I went back to the defendant's original Court of Appeals brief to see what he said about preservation. And then, through the response and all that. Where did this new test that the Court of Appeals came up with for 6405 compliance come from that says that if it's not altogether different from what was argued below, it complies with the timely and specific requirements of 6404? I can't figure out where that, I mean, I don't think it came from either of the parties. Is that right?
It was not in the either the brief of appellant or the brief of appellee. I know the appellant filed a reply brief that the court referenced, but other than that, I think it came out of whole cloth that if an issue is litigated, then anything goes on what the argument can be raised on appeal, because that's what they essentially did in this case. I cited City of Overland Park versus Cunningham, which is an interesting case because it's in traffic court or district court on a DUI case, objection foundation judge. And then the defendant would write down what the objections were, give it to the judge. The state wouldn't see this. And then the state would make whatever, go through its foundation, and then the judge would make a ruling. And the court said that was the ex parte communication, number one, but the trial should not be a game where counsel is forced to guess what the objection is and what the trial court considers as lacking. And 6404 says that it has to be a specific objection, so stated as to make clear the specific ground of the objection. And here, when you look at the objection to CK, for example, the objection at the motion hearing, I'll give them the motion hearing objection. And it was a sex act, judge, but it happened after the fact. That's different from going on appeal and saying 6455G doesn't include any of the things that the defendant did. Because if you're going to tag a trial court with you made a mistake, this issue was presented, they should have a chance to look at that first. In Bliss, the court said the key is whether the objection is sufficiently specific that it can be analyzed by the trial court so the appellate court can review the trial court's analysis that is in the record. And there's no way the trial court can do that. And I can tell you that because I'm looking in the record for, okay, well, what statutes under Article 55 of Chapter 21 would be violated. I'll look in the state's memorandum or the defendant's memorandum. There's nothing there. I'm making up what subsections would comply with 6455G for it to come in. There's no analysis by the trial court on this, and there's nothing to review. And in fact, the court says, we find the purpose, this is at page 10, we find the purpose of 6404 was fulfilled. Scheetz has preserved his claim for review. Now we must turn to the analysis of the district court's admissibility of this evidence. Since the court's decision hinges on its interpretation of 6455, we're presented with a question of law with unlimited review. With all due respect, that was not, that issue was not presented. And I haven't in the petition for review, Appendix B has the litany of the discussion on all the witnesses. CK, GH, and HT. HT was sent a Snapchat of inappropriate male part pictures, and the defendant offered to buy HT alcohol if he would come to the hotel and buy her alcohol, which she didn't do, and because she thought that was weird. The purpose of 6404 was not complied with, and the court's ruling in getting to the issue is at odds with King, Cunningham, and State versus Bliss.
Kind of running.
Okay.
If we get to the 6455G question,
Right.
what's your argument that it was not exclusive, but kind of exemplary, that it goes beyond just the specific criteria that's set forth in G? Tell us your argument.
My argument is I was in this courtroom in 2005 when State versus Gunby was argued under 6455B, and the court said that the list of acts, including motive, opportunity, intent, plan, preparation, lack of mistake or accident, That's a non-specific act. And if you're going to introduce marital discord evidence, you've got to fit it under 6455B. And so we have that subsection that says it's non-exclusive. And so now we're going to say subsection G, which says it includes 10 different crimes, is exclusive. When we can say the legislature enacts laws with the understanding of what this court has said about that. And the legislature amended 6455 within 3 months after Prime 1 came out to make it so that sex offenses can come in these types of cases. That is my argument on that, and that was the next issue I was going to go to. That there certainly wasn't a lobby of people wanting to Snapchat their penises that appeared to the legislature and said, "Hey, give us an exemption on this so we can do that." And that assumes that any of this stuff isn't within Article 55 of Chapter 21 anyway. And I argued that the offering alcohol to a minor with intent to commit a sex crime could include that, or offering or soliciting someone to send a naked picture of yourself could be soliciting to commit a solicitation on that case. So assuming that the court gets to that issue, that there were exceptions under Article 55 of Chapter 21, but if not, then it's a non-exclusive list. The next issue, issue 3, the internet search history issue. I don't think that's really a 6455 issue. I think it's whether it was just relevant evidence in that case. And I cited a case in my 609 letter from a different jurisdiction on that issue, but there's a lot of cases from other jurisdictions on that topic, and that the really wasn't an obscenity issue in that case.
Was that at issue in the motion to introduce propensity evidence prior to trial? Was that so the reason given for wanting to introduce that was that it was propensity, or that it was just relevant otherwise?
I think it was included in the 6455 motion and was discussed at the motion hearing. And defense counsel at trial said, I don't think it's relevant, and that it's prejudicial outweighs the value of it. And the judge ruled that did rule that it was a 6455. It was admitting it under 6455, I think. And that's Appendix C in the petition for review, the colloquy on that discussion. I see I'm out of time. I've already talked about issue 4 briefly on the inferences and closing arguments, so I will take a seat.
May it please the court. Again, my name is Jacob Nowak. I represent the appellant Mark Scheetz. Unless otherwise directed, I intend to start with issue 1 and get to however many issues we can get to therein. The state's argument essentially boils down to this court has previously interpreted the language that was now included in subsection B of KSA 6455 inclusively. So it should instinctively interpret subsection G the same. And while that argument is enticing at first glance, it does not survive any level of closer scrutiny than that. There are a myriad of reasons identified both by appellant and the Court of Appeals for applying a different interpretation, or at least its own statutory analysis to subsection G. I want to focus on 3 of those initially. The first being that the basis for this court's inclusive interpretation of subsection B does not exist. When we court interpreted the language that's now included in subsection B as inclusive in State v. Gumby, because it determined the legislature codified a then existing common law rule when they enacted that language back in 1963. Subsection G came around in 2009. It was not enacted as a codification of then existing common law. It was enacted in response to this court's decision in Prine, and it was modeled not after common law, but after federal rules of evidence 413 and 419. So the basis for inclusive interpretation that existed with subsection B does not exist with subsection G. Next reason that this court should apply a different analysis is because the scope of these exceptions are different. When we interpret statutes, statutory languages within the same statute, we look at how those exceptions or subsections interact with the statute as a whole. Our general rule is prior crimes evidence is not admissible to prove propensity evidence or a person's propensity to commit the current crime. Subsection B is a very limited exception to that. It allows prior crimes evidence to come in to prove some other material fact. But when you do that, the jury is then instructed that you are limited to considering this evidence only for that limited fact. Subsection D is not a limited exception. It is a total exception to the bar on propensity evidence. It allows for sexual evidence of sexual misconduct to come in for any purpose the court sees fit, which this court has interpreted to include propensity evidence, a total exception to subsection A.
So, since we understand that's your argument, jump to the second issue. Where did the district court have the opportunity to rule on whether subsection G is exhaustive or illustrative?
Issue was heavily litigated both pre-trial and
Let's just take the testimony of GH, who's the 11 and 12-year-old who your client says he sent a picture of his erect penis to. Where in your objection to that testimony did you tie the subsection G objection to?
Well, they didn't tie subsection G directly in their argument below, and the prosecution did not tie subsection G to their motion below, and the court did not tie subsection G to their analysis below.
Let's just be clear. The district court did not rule on this subsection G issue, right?
Suppose if that's the way you want to couch it, I disagree. You admitted evidence pursuant to subsection D.
But it didn't make any ruling whether subsection G is inclusive or exclusive. It simply admitted the evidence based on the objections that were made by the defendant at trial.
That's error under the plain language of Gumby. When this court issued Gumby, it included.
I don't want to get off this for a second because your objection to DH's testimony was, the defendant's objection was that it wasn't very specific. That's the objection.
The objection was it wasn't admissible under KSA 6455.
The objection, but you've got to give a specific reason why it's not admissible. You don't get to just say not an objection. You just don't get to say objection, right? You have to give a reason for it in order to preserve the issue for appeal.
I don't necessarily agree because of the language of Gumby. Gumby is an exception to this. This court found that if the court does not apply each and every safeguard of KSA 6455, then we will find error. That is the language of this court in Gumby. Part of that is determining that the evidence is admissible, whether if it's coming in under B, that it is a material fact. If it is coming in under D, it is evidence of sexual misconduct. That is one of the safeguards of the statute. The court has an affirmative duty under Gumby to find that. If not, this court will find error. It's pretty strong language in State v. Gumby. So I think the objection gets us there.
The objection was it wasn't admissible under D because it wasn't specific. And that's language, in the statute. That's what the district court focuses on. Then we come up to the Court of Appeals and we make new arguments. And I get back to this new test that the Court of Appeals has come up with for 6404 that says if it's close enough, then we're going to go ahead and rule on it.
I disagree with that assessment that is what the district court focuses on. I believe that a reasonable district court, when they get a motion to admit evidence pursuant to a statute, and then there's opposition to that statute, that a reasonable court would take out the statute and read that language in its entirety. They are the gatekeeper. They are responsible for the admission of any evidence. So I think it is incumbent upon them to read the statute, which includes KSA 6455 in it. That said, I think we've missed the forest for the trees here a little bit, because if there is any sort of preservational hurdle, be that it wasn't a specific enough objection, ultimately, the result in this case is most likely going to be that he gets a new trial, because we already have, first, it kind of misses the point of the entire petition for review, which was the main basis of this petition was the state wanted this court to interpret the language of KSA 65G. If you were to make a preservational ruling, then you're not addressing the merits, which means the Court of Appeals decision on the merits is good law. It's been reversed on other grounds, but the merits is good law, binds all district courts to that language, and it's certainly good law of the case. So our prejudice prong in any subsequent 1507 would be met. And we can't say that this was a strategic choice on behalf of counsel, because they fought tooth and nail to keep this evidence out. They litigated it pre-trial, they litigated it at trial. Now, if they didn't say the right words, that just becomes a Dinkle issue, because we expect reasonable counsel, effective counsel to know the language of the statutes. So all we'd be wondering there is, did you know the language of the statute? Why didn't you make the correct argument? It wasn't a strategic decision. Prejudice was met. If they didn't know the language was there, or they just failed to say it specific enough for this court, that's going to be almost certainly ineffective assistance of counsel. So we are at that point just delaying the inevitable of getting to a second trial. And I don't necessarily think it's fair to place that on counsel, because the court did have the opportunity to have this trial without the tainted evidence. They just had to conduct the analysis properly. They did. So my suggestion on if this court finds there to be any sort of preservational hurdles would be first to hurdle that themselves, if not to take it upon themselves to do a Dinkle type remand, or to remand it to the Court of Appeals to address the standing preservational exception that is before them.
I don't understand your argument. It's a little bit, I gotta connect a lot of dots here.
Sure.
You're postulating that down the road, there might be 1507 and counsel might be found to have been ineffective for failing to preserve the subsection G argument.
If this court finds the issue is not preserved, I don't think there's any possibility other than counsel being found.
Well, okay, so I'm tracking with your argument. And then you're saying that because of a vacated Court of Appeals ruling, that somehow proves prejudice?
If this court does not address the merits, if it doesn't reverse on the merits, that is a minimum the law of the case. I mean, the court still
How is it that I guess I don't understand that. If a
we
Court
have
of Appeals decision is reversed on
grounds.
the grounds that they should never have reached the merits and the opinion's vacated, how is it law at all? I don't understand that.
They still did reach the merits. We still have
But if a higher court vacates that ruling,
I think it works that way if you don't reverse on the merits. I think you would have to reverse on the merits to negate their logic. Certainly, at the very least, you would agree would be persuasive for the district court that is reviewing it, that we had a 3-panel judge Court of Appeals all agree that this was error and it was reversed.
Can I, you just from the record,
No, go ahead.
I just wanted to make sure that I'm not missing anything else on the record in terms of like, was there at any point defense counsel renew as a sort of continuing objection, the pretrial issues and arguments that were raised, or what we have in terms of a direct, contemporaneously in time is what it is?
I don't have the record cite before me for this court. I did certainly cite to it in my original brief. The way it was addressed at the outset of court was they had indicated that this was going to be an issue, that they wanted it to be preserved. And they asked the court their opinion on how they wanted it to preserve. But my recollection is the court did not mind if they just preserved it from the outset, or if they wanted to do that with each individual witness. Obviously, they elected to do it with an individual witness. But I think that conversation, at least at the outset of trial, incorporated any prior arguments that were made from the pretrial hearings.
And I appreciate this is speculative and the argument wasn't made, but I'm looking at this and I'm thinking about how it used to be pre-statutory amendment that allows propensity evidence in on these types of cases. I'm just looking at the three instances that were testified to by different witnesses in this case under 6455. It just seems to me, couldn't an argument have been made absence the propensity amendment? That could have come in, couldn't it, under the exceptions that were allowed, even the non-exhaustive list under identity, mistake of fact, there's all kinds of things that would allow this testimony to come in. And I appreciate your argument. There's no cautionary instruction on all of that, but it just seems to me that this would have fit even under the old rubric.
You touched on the primary problem. One, the issue isn't necessarily before the court.
I
because it hasn't
understand all
been
that,
raised way.
but boy, it just seems like
it's-
this is traditional kind of 6455 that would have gotten argued and very possibly would have come in anyway.
Court places a lot of value on those limiting instructions, and I do too. That is a presumption that the jury will follow that they will not use it to determine that this person is
I
some
understand
sort
the
of-
distinction here. There's
Right.
no cautionary instruction about propensity and all of that, but
that reason. I don't think it can be, even if it had been argued, corrected as right for the wrong reason on appeal.
Let me move you over to the prosecutorial error side of this thing. And the Court of Appeals found that it's error for the prosecutor to say that draft to GH was of an erect penis. Then the Court of Appeals said, and it's clear that by saying that, the purpose of the prosecution was to inflame the jury. So that became I wrote down in my notes here, they got a twofer here. You know, one error and there's two things wrong. But how can it be either? When we know that defendant said it was an erect penis and it's in the record and in the evidence.
So ultimately, this isn't going to matter, but I do want to make it clear. You can certainly make an inflammatory argument that's based upon the evidence that was presented. The classic inflammatory argument I always cite to is the one where, I forget the name of the case, but they asked the jury to consider how the mom of the deceased felt on Mother's Day. Well, the mother testified at trial, so there was evidence that the victim had a living mother. Like, that was based on the error or evidence, and it was also highly inflammatory. We didn't make the argument below that describing it as an erect penis was inflammatory. We made an inflammatory
Oh,
argument.
you don't
regarding
have to.
some
I mean,
other-
this
I
is closing
understand.
this closing argument. I guess I want to focus on if it's a fact in the record.
Mhm.
It can't be error for counsel to mention the fact that's in the record.
I think you can step over a line and make it inflammatory, even if it is in the record. In this case, I don't think it would be if they were describing it based on how it is, how we now know it is actually described within the record. And I guess just to do a little house cleaning on that issue, we've
It
obviously.
becomes important because it's the prosecutor, when you get to cumulative error in the way the Court of Appeals did this, second you get prosecutorial error, then you're in constitutional land for all of the errors that are being accumulated.
Right.
And so this is a big deal. And so the mistake is not small, or the error is not small on behalf of the Court of Appeals reference here. Taken, and it's a big deal.
And if you're talking about just that we got to cumulative or constitutional cumulative harmless.
You got that test in cumulative because of prosecutorial error, and that was one element of it.
In that context, I don't think, at least in this case, that the misstep was that significant, because there was a second error they found. That is unquestionably a misstatement of the evidence. That witness never said that they believed that photograph was set intentionally. Ever. In fact, they not that witness individually, but his law enforcement partner said that the two of them came to the conclusion that it was sent accidentally. So that's,
No, but then they said, well, we're gonna go ahead and send this to the KBI, which isn't, I think it's not a bad argument for the state to say that it's okay to infer.
oh, absolutely. That's
rest of
not what
this
they did.
Because they've made a conclusion to send this on to the KBI. There's gotta be something wrong with it.
I agree with you entirely that the state could have argued to the jury that based upon the evidence, they may draw that inference. They crossed the line when they said a witness already drew that inference for them. That was a misstatement and fabrication of the evidence. That's prosecutorial error. Your Honor, I see my time has expired. I'm happy to entertain any final questions.
I have one question. If we get past the preservation issue and we're into the definition of an act or of sexual misconduct, under G, and then 1 is kind of the catch-all, right? Anything that's in Article 55 of Chapter 21.
Also,
Right, exactly. So what is the standard of proof for that? If you are moving, I guess, to admit evidence under D, what is the standard of proof for that? So for example, we have, CK here, he asked her for a nude picture. She didn't respond. He sent her a nude picture of himself. She blocked him on that particular, on Snapchat. Then he goes to Facebook and says, why on earth did you block me? Is that, if you're going to try to show that that is a violation of Article 55 of Chapter 21 or 216419 through 6422, what is the standard of proof? Preponderance of the, how do you decide whether it fits one of those crimes? And who has the burden?
I think, so it comes in, there's a test under Boyce law that includes how, one of the factors that you consider is how thoroughly the state proved. And I might be misstating exactly how that's stated in Boyce law, but that's one of the factors the court should be considering before they admit evidence under KSA 65D. I don't know what the standard would be at the trial court. I think for us, sufficiency of the evidence is adequate here. There is not sufficient evidence that
No, but I'm specifically talking at the trial court.
the trial court, I think it's a moving target because there's 6 factors that are listed in Boyce. I believe it's 6 factors. I apologize if it's a different number, but I would suggest it has to be a minimum of preponderance of evidence.
And who bears the burden?
State of Kansas has they're the one who are producing the evidence. They have the burden of establishing, if we're going under subsection 1, that it is within Article 55 or that it is within 64, 119 through 22, which by the way, those were added after the statute was amended, would seem to belie the state's position that this was adding examples to it as we're going on. But yeah, it's the state's burden to present the evidence.
So the state makes a motion to introduce this propensity evidence, and the objection by the defendant here is this isn't specific enough. I don't have this stuff right in front, but it's not, it's nothing under G, right? They don't say, well, it doesn't fit any of it, anything under G. It's like other objections, right?
Yeah, I would push back a little bit when it came to the internet search history. I think
Okay.
the trial objection there, while they didn't use the word G, they argued that it was not evidence of a crime, which it's not. And so that definitely brings us in. So the preservation argument, to the extent it has anything that falls flat when it comes to the state's exhibits, I think it's 121 and 122. But yeah, I think it's the state's burden when they want to admit evidence through D to establish how it qualifies as sexual misconduct under G. That should become just common practice moving forward, that they list that in their motion. This is sexual misconduct because it is, I suppose, evidence of, commercial sexual exploitation of a child is one of the ones that's in our case. And I think that that is most likely what the state will do moving forward now that Court of Appeals has at least recognized the error, and hopefully this court will affirm the Court of Appeals. That is what we are asking this court to do. I realize we did not get to every issue. My time is up. Unless there are other questions, submit those issues on the briefing. Ask the court to affirm the Court of Appeals, and thank you for your time.
No questions. Thank you. Mr. Obermeyer, you reserve 3 minutes.
Thank you. I'll try to answer some of the questions that were asked of opposing counsel. Justice Biles, you're right. The defendant got the elevated harmless error standard because of the closing argument that was not improper. And the Court of Appeals even said, we don't find this to be erroneous on itself. And that's even when it thought there was no evidence of the erect penis, which we now know that there was. Concerning the other whether the officer believed it was intentional or not, at volume 21, page 18, the state argued, and it's the beginning of its closing argument. Once the sheriff had information that Norton PD was investigating the defendant for exactly the same behavior with another girl, he started to think it wasn't an accident. He started to think it's an intentional act on behalf of the defendant, that he's not just accidentally sending pictures of his erect penis to random teenagers. I think the evidence would support that comment, and that did not impact the jury's verdict in that case. Justice Wall asked a question about ineffective assistance of counsel for not making this argument. As I understand the case law, I'd be happy to defend these two attorneys. I think one's been an attorney since '87. If there's no published case on the law like the Court of Appeals did, how can you be ineffective? You cannot be expected to be a prophet to predict what the court's going to do in the future. There was no state v. Scheetz for the attorneys to say, well, we think some future court might apply subsection G and say that it's a specific list. So I don't think that counsel would be ineffective on that, and that's still not a reason.
We've really gotten past that. I mean, I'm old
Right.
enough to remember when that used to be a frequent argument that, don't pay attention to 6404 because we'll just be back on an ineffective assistance of counsel, and we haven't changed our case law. So it just seems to me that can't be the reason, nor a legislative mandate. Now, whether it fits or not within a mandate is a different question, but 6404 has got to mean something.
Right. And
Besides just I object,
right. To say objection 6455, when if you look in the supplement to 6455, there's 409 case annotations in the current supplement. So as a judge, how's a judge supposed to intuit what the objection really is out of these 409 case annotations? And you're right. There is no bypass on 6404. I think there's a Garcia case that says that. There's other cases that say that. I see that I'm out of time, but I would.
I meant to ask you this
Sure.
on your is issue 3 having to do with internet search history,
Yes.
and is it specific to internet search history when sexual misconduct is alleged? It just, if someone looks at my internet search history, and I'm not divulging anything that I think is improper, but if I searched something about gin, and I'm looking at what's the best gin, and I'm pulled over for a DUI, is that internet search history somehow relevant to that? I mean, it just seems like I think it's dangerous territory just to say you looked at this or you searched for this, or maybe didn't even look at it, and somehow that's relevant. And it means that you maybe had the propensity to commit this act or the act. How do we draw the line here? Because we're getting into desire, attraction, and all that kind of stuff that's pretty nebulous in terms of what it means. And I don't know that it is relevant. So tell me why it is.
Sure. In the initial state's brief, I cited a case involving a defendant searching for guns, certain caliber of gun, and that was relevant in that case. So I think with your gin example, it would have to be somehow tied into the court to be relevant. In this case, the judge found that it didn't say that he wasn't going to start molesting teenagers. It just said it showed what his interest was or what he was thinking about, not necessarily that he was going to do that. And I think the judge,
It can be a pretty big leap, I think.
right. And I guess it goes down to what is being offered to show, but I think it's different from the Bolin and the other case here where you're trying to impeach the defendant's statement by showing that he's heterosexual or homosexual by showing what he has viewed. I think this is
How is it different?
I think it's because it shows the defendant has an interest in stepfather, stepdaughter, sexual contacts, or at least has researched those types of things. Not necessarily that he's going to do that, but had an interest of it. And under your questions of opposing counsel, it may have come in under the old 6455 to show a lack of mistake or accident or an intent or something like that. But I did cite a lot of cases in the supplemental brief and the original brief on that issue.
Can I just ask you one last question? I heard your argument going back to preservation that, it can't just be objection 6455. But, given the constraints of trial and the pressures of trial, when that issue has been litigated fully, including the subsection G issue, why wouldn't that? And I'm not suggesting that's even what we have in this case, but why wouldn't that be enough, sort of that catchphrase, when you've already gone through the process of litigating that pretrial?
When I think in this case, defense counsel said, I would like to reference my objections, incorporate my objections at the motion hearing on admitting this. And so then the 6455 was just code for what I made at the motion hearing. So I think that was whatever objections were made at the motion hearing were preserved. It just wasn't that it's a non-exclusive list or that it's an exclusive list and none of these are crimes under here because there's nowhere where the parties are talking about, well, what crime would that be that is being
Specificity.
right? Yeah, right.
Isn't your point, though, that this is different from saying one thing in a little bit different way, such as instead of saying objection foundation, you say objection, this witness couldn't possibly know that information that he is submitting as an exhibit. I mean, that's really another way of saying objection foundation, right? And that can be done. You can say the same objection in a different way as long as it's specific, right?
Right. As long as the trial court has an idea what the objection that's being made is, it could be stated differently. But here to say us to CK, well, this happened. We agree it's a sex act, but it happened after. How are you cluing in the judge that there's an error?
So your position
that?
is that this is just simply not another way of saying this objection. It's a completely different objection.
Correct. It's not specific as to that. And as to GH, the defendant in his statement to the KBI talks all about, yes, I sent that to her. It was a mistake and I'm sorry.
Well, what would you say to opposing counsel saying that it's not their obligation to object? It shouldn't be based on the objection because it was the state's duty in the first instance to show that it qualifies under G by a preponderance of the evidence.
I think the fact that defense counsel, one of the statements made at the motion hearing was, I agree that it's, I don't have it with me, but it's a sex act, but it happened after, isn't saying, I think this isn't in that laundry list of crimes in subsection G. I mean,
So there
they're
was actually
saying
an affirmative statement that they did agree it was a sex act.
that it, correct. And up until the Court of Appeals in Gunby, nobody thought that, you know, this list of sex acts in 6455. I mean, you would just think that the things that happened here would be
Well, does it-
sex acts
Yeah.
that would come in. So I think that's how I'd answer that. If there are no other questions, I would ask you to reverse the Court of Appeals and affirm the defendant's convictions.
Thank you to both counsel for your arguments this morning. The court will take this appeal under advisement.